Well, I'm overjoyed to be here because I live in Minnesota. I flew in yesterday, immediately went running, went swimming, soaked up way too much sun. My face isn't usually this bright red. So I want to thank Mike and Steve for inviting me. They actually rejected my paper for the, but then they said, but would you care to come and comment on a paper? And I said, well, let me get this straight. All I have to do is read an interesting paper, come, and you'll pay my way to spend 3 nights in San Diego and soak up. I'm offended. But I'm really glad to be here, and I'm really glad to have been assigned Jamal Green's paper. He's a brilliant new young scholar, and it set me going and looking at a lot of his other stuff, and I like it a lot. I find this paper wonderfully interesting, terrifically engaging, and provocative. Unsurprisingly, I'll agree with some of it, I'll disagree with some of it, and a lot of things I just kind of come at sideways to it, just a different perspective. And hopefully, when I throw punches, it won't be in a mean spirit. There basically, I see 2 aspects to the paper. One is this methodological question. What do you do when you're interpreting an incorporated right? Is it the meaning of that right in 1791, or is it the meaning of the right in 1868? And I think that's an interesting and important question, and one that's worthy of discussion and frequently overlooked. And so I'll be talking about that for a while, and some ideas about that. Then the second part of the paper, which is the backside of my little handout, is what I call the psychological or sociological social studies question. I dub Originalism on the couch, where Jamal psychoanalyzes what's motivating us, what's really driving us in that. And unsurprisingly, I'm a bit more skeptical about this, and I'll have some objections to raise there. In the end, I find that not as helpful. But let me start with the methodological point, reincorporation. And here I'm going to tell a story on one of the conference organizers, Mike Rappaport. Okay, a long, long time ago, 1989, I'm interviewing for a job with Office of Legal Counsel, OLC, and Michael is one of my interviewers. John McGinnis is eventually one of my bosses. Unbeknownst to them, I'm about to become unemployed. I've been fired from my $22,000 a year public interest law firm job, and I have just a few weeks left. But I'm interviewing with them, and they ask really good, hard, substantive questions. These are Reagan administration holdovers, and they want to make sure I'm pure, or at least have good, sound thought processes about legal interpretive method. And I remember the question distinctly. It was kind of a technical question having to do with interpretation of the civil rights attorney's fee shifting statute. I think Ben Cohen was in the room, and he was probably working on this project. Okay, this is section 42 U.S.C. section 1988, which in its language originally provided, and I think it still provides, that when you prevail in a civil rights suit against state government officials for violation of constitutional or civil rights, the prevailing party is entitled to a reasonable attorney's fees. Okay? The Supreme Court early on interprets prevailing party to mean, well, prevailing plaintiff against the government. It said prevailing party, but ordinarily, if a defendant beats down a civil rights action, the defendant, government, isn't entitled to a award of attorney's fees, because that'd be contrary to the policy. So they interpret the statute to mean something different from what the words literally say. Okay? Now, then here's the hypothetical they present to me. Congress reenacts the statute using essentially identical language of prevailing party, but against the legal backdrop of a prior Supreme Court authoritative interpretation that read the words to mean not quite exactly what they said. What do you do then? And I think I satisfied them with the answer. I said, well, of course you should go with the text and not with the contrary intention, but if at the time that they are adopting the revised statute, the term prevailing party within this context had acquired essentially a term of art meaning by virtue of a received authoritative construction, so that it meant in the understanding of the people who were adopting it, okay, sort of a variant of objective public meaning, prevailing plaintiff, then that would actually alter the meaning. Okay, and I think Jamal Green's question is essentially that same one. And I think the question on the 14th Amendment is, did this sort of thing happen with the incorporation of the Bill of Rights via the Privileges or Immunities Clause? And, so I reframe the question to be a lot simpler if the 14th Amendment had said something really nice and clear and unequivocal like, We hereby incorporate by reference and apply as limitations on the powers of the state government the precise original public meaning of the individual liberties set forth in the Bill of Rights as it would have been understood by a fully informed, objective speaker and reader of the English language at the time of their adoption, notwithstanding that those liberties at the time were understood generally to apply only to the national government. Okay. If they basically had said nice and clearly for us, we hereby adopt the 1791 original public meaning understanding. That's what we intend to incorporate. Okay. You could also suppose something opposite. We hereby incorporate by reference and apply as limitations on the powers of the state government the provisions of the Bill of Rights as they are understood today at the time of the adoption of this amendment, now, 1868, or as they have become authoritatively construed by the courts. Okay? Now, the reality is that the Privileges or Immunities Clause doesn't really say either of those things precisely. Instead, it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, and that the Congress shall have power to enforce by appropriate legislation the provisions of this article. I think in the end that gives Congress broad interpretive power in terms of resolving some of these questions of textual ambiguity or what some people call construction and some people call framework originalism. Now, as between option 1 and option 2, whether if you're construing the Privileges or Immunities Clause we actually have, they more likely intended the first or the second, or that their language more accurately should be understood as the first or the second, I tilt more toward the first, ordinarily. While in principle, I think the meaning is the meaning in 1868. I think the objective original public meaning of the Privileges or Immunities Clause, to the extent it's understood as incorporating the liberties of the Bill of Rights, is probably best understood as incorporating those liberties as they objectively were. Now, it's possible that the meanings had shifted over time, and if there were a definitive judicial interpretation that the framers of the 14th Amendment appeared to be legislating against, writing their provision against the background of, that would alter it. Now, I don't think this is absolutely clearly compelled, because I think it is the case that incorporation through the Privileges or Immunities Clause can and sometimes does change the meaning of the original provision. Okay, this goes back to stuff Akhil Amar has been saying for a dozen years or so. One aspect, and this is not Jamal's point, is that the language of privileges or immunities itself alters somewhat the meaning of the Bill of Rights provisions because it affects what it is that has been incorporated. To a certain extent, the original Bill of Rights provisions were federalism-oriented. Kurt Lash's scholarship is great on this sort of thing. So that the Establishment Clause, if originally a structural principle of federalism, no national interference, states can do what they want, if incorporated as a privilege or immunity, is limited to the privilege or immunity of freedom from non-establishment, whatever its content. Similarly, if the Second Amendment, as against the federal government, were originally understood as protecting the right of state militias to arm themselves, when incorporated through the Privileges or Immunities Clause, to the extent it is the privilege or immunity of citizen, it becomes more of an individual right. And you can play this sort of thing through the Seventh Amendment to the extent you think it's a federalism provision, and there are difficulties, special difficulties with the Ninth and Tenth Amendment. The short point is that incorporation does, to some extent, change original meaning because it changes what has been incorporated and what is adopted in the 14th Amendment. Similarly, the Privileges or Immunities Clause says, no state shall make or enforce any law, which might subtly shift questions like the meaning of the Free Exercise Clause. If you originally thought that it was no law prohibiting the free exercise of religion and that might support a reading like Employment Division versus Smith, that it's not really a law prohibiting because it is a neutral law. If you view it through the lens of shall not make or enforce, then the question of whether or not you can apply a legal requirement in such a way as to, in effect, abridge someone's free exercise of religion might be viewed differently. Now, those are different types of ways in which incorporation might alter or shift meaning somewhat. Now, Jamal Green's position is a little bit different, as I understand it. It's that the meaning of terms like speech or religion or arms or search or due process of law, or jury, I think that one's actually plausible, might be different meanings in 1861 than 1791. Have the meaning of any of these terms changed between the time of their first adoption and their second incorporation? Like the meaning of the attorney's fees statute, when Mike Rappaport quizzed me on it. And I'm open to that possibility. And I think Jamal is right that originalists, to be principled, need to be open to that possibility. That's got to be the right question to be asking. And the answer, I think, will depend on the strength of the evidence of changed meaning in any particular circumstance. Now, I doubt that it very often makes a great deal of difference. And I think that that's probably the reason, more than any hero worship of the founding generation, why originalists tend to go to the shortcut of going straight to the historical evidence of original meaning, because often it doesn't make a difference. Okay? This brings me to originalism on the couch. Jamal Green asks, why do originalists give these issues insufficient attention? He says this is a phenomenon that is in need of an explanation. Well, I'm not sure that originalists don't give them sufficient attention. They could give them more, and I think it's a good point, but I don't think this requires an elaborate explanation. I think the explanations are actually pretty simple, and if you use Occam's razor, you can find much simpler, non-psychological explanations than the ones Jamal offers. And in the end, I'm going to explain why I'm not persuaded by them. Okay? And I list a couple of them, and I put them in shorthand, kind of snotty form. I don't mean to be quite so snotty, but Jamal says that originalists like restorative narratives, you know, hero worship going back to the framers, rather than redemptive ones. The 14th Amendment is primarily a narrative of redemption. Well, I don't know about that. I like redemptive narratives. My religious faith, New Testament, the life of Jesus, is a redemptive narrative, not primarily a restorative one, though the two link up at certain points. I like Civil War and Reconstruction. I like Lincoln. I'm such a nerd. I like Bingham. And I'm not a big fan of Thomas Jefferson, a racist, slave rapist scumbag. Oh. Sorry, wait. This isn't on the internet, is it? Okay. Well, oh boy. I think the short point is that, you know, some people do like originalist original era narratives, and some like Reconstruction narratives. And mostly, I think it's irrelevant to the question of proper interpretation of a legal text. Okay, another quick point. Jamal Green says that originalists desperately are seeking certainty. The 14th Amendment doesn't give that certainty. The chief aim of originalism is settlement, and the 14th Amendment tends away from settlement. Well, I'm not sure that all originalists seek certainty. Some do and some don't. But more fundamentally, I think this collapses the distinction between what biblical scholars call exegesis. Right? Legal scholars use their own jargon. But exegesis, interpreting the meaning of the text, as distinguished from hermeneutics. What are you going to do with it? How are you going to apply it? Okay? Originalism, original public meaning textualism, is, I think, a theory of exegesis, not a question of hermeneutics or application. I think you need a theory of adjudication, what you're going to do with the text once you understand its meaning. So I'd be so bold as to say exactly the opposite of Jamal's position. I think determinacy is irrelevant to originalism. Rather, determinacy is essential to adjudication. Okay? To the extent the 14th Amendment is indeterminate, that means you need a theory of adjudication about when courts can and cannot act where text is indeterminate. You know, that's why I think the Section 5 power of the 14th Amendment is so important. My reading of the 14th Amendment is that it's a broad grant of power primarily to Congress to fill in the interstices of open-ended text. He also talks about stare decisis, also the fear, originalist fear of being irrelevant. I love being irrelevant. I think that's my job, is to be as irrelevant as possible. That's what academics are supposed to do. Fear of rejection. I don't care what people think. Now, maybe some people do, but in the end, all of this sort of analyzing of originalists strikes me as just a little bit stereotyping and unhelpful and unnecessary. Okay, it's interesting as a social science observation, what originalists tend to be like, but I don't think it's a very good critique of originalism as an interpretive method. I think that originalism is a theory working itself pure. A lot of us haven't thought through all the implications of 1791 versus 1868. It's good to point it out to us. It's a little bit under-theorized, but probably in most of these judicial opinions, they either hadn't thought about it or they're engaging in a linguistic shortcut because the evidence doesn't persuade them that there's a big deal of difference between 1791 and 1861. So the better focus, I think, should be working on getting originalism right. Okay, getting originalism off the couch and into the game.